approve of amending that.
I do.
Can you state your name, your record?
Frank Anthony Brancato.
Mr. Brancato, how old are
I'm 74.
you? What's your highest level of education?
My highest degree would be my law degree from Capital University. I took some master's course classes at Ohio State University.
Okay. What's your occupation?
I'm a practicing lawyer in Owensboro, Kentucky.
You are familiar with the deposition process?
I am.
Have you ever been deposed before?
Yes.
Okay. You understand that this is essentially a conversation we'll be having. I'll ask a question. You will answer. If you don't understand the question, you can tell me one more time. You all hear the counsel? If you need to consult with counsel, just let me know, and you can consult with counsel. And then please answer all questions with yes or no or audibly. Do not use shake your head, because we are making a record of this, and we'll have a transcript to look at. Do you understand? Okay. Now, generally, can you describe your relationship with Jim Ludwiczak, Martha Ludwiczak, and the Ludwiczak family?
I met Jim and Martha Ludwiczak sometime in 1983 or 84. We developed a friendship and relationship with them and their family. Over the course of the years, we vacationed together through the 80s, into the 90s. Actually, most recently, probably 4 or 5 years ago, when on vacation was in Florida with Jim and Martha. Some of the vacations we took in the 80s and 90s were with the entire family.
Okay. Have you acted in the past as, I guess, just the family attorney or counsel for the Ludwiczak family?
I did a couple of times. Let's see, I did when they acquired the property at Windsor, the Windsor home, they asked me through PNC Bank to handle that transaction.
Okay.
There was a time when Martha was prescribed some wrong medication from a drugstore, and she had some adverse reactions to that, and I met with her and helped negotiate a settlement resolution of that. From time to time, Jim asked me things about his liabilities and his work, legal issues related to his consulting business.
Okay.
And then I think I answered some questions from Martha concerning her mother's estate.
Okay. Now, you are aware of the lawsuit involving Jim and Barrett Ludwiczak?
I am.
Okay. And you understand that involves the property at 1728 Windsor Avenue?
I do.
Okay. Describe the circumstance in which, to the best of your recollection, Jim and Martha Ludwiczak came in possession of 1728 Windsor Avenue.
Jim and Martha contacted me about buying a home in which they would allow Barrett to live in. They told me that Barrett was having trouble keeping a residence, and that Barrett had a girlfriend who was now pregnant with his child, and they did not want their granddaughter to become homeless. So their plan was to buy a house and rent it to Barrett, buy it with a lot down so that the mortgage payment would be smaller, something that Barrett and his girlfriend could afford. and that's what they did.
Okay. Now, we've previously spoken, and I had asked you if you had copies of the deed of conveyance for that. Do you have copies with you?
I thought it just gave them to you.
Oh, I think we yeah. Thank you. And you provided extra, thank you. I'm going to hand you a copy. This is the deed you provided. Here you go. We have this marked. I know we have some pre-marked exhibits. We have this marked as Exhibit 3. Bless. You have a copy of this deed in front of you, correct?
I did.
And it is marked as a record in Deed Book 786, page 274 in the office of the Davis County Clerk. Is that correct?
Yes.
Okay. If you don't mind, take a second to review that deed, just to familiarize yourself with it as much as you can.
Okay.
Okay. Now, this looks to be, I guess, Jim and Martha Ludwiczak purchased this house from a Danae Orleans and paid $68,500 for the house. Is that correct?
Yes.
And that's reflected in the deed. Now, if you don't mind, at the very bottom of page 1, would that be the addendum clause?
Yes.
It says that is for and during their joint lives with remainder in fee simple to the survivor of them as tenants by the entirety. If you don't mind, can you explain to me what tenants by the entirety means, as you understand it?
Well, tenants by the entirety is a legal fiction where the Martha and Jim each owned 100% of the property. There can only be one 100%. So the legal effect of tenants by the entirety is that when the first party dies, on the moment of death, the survivor owns 100%. There's reasons to do that for estate planning purposes. There are reasons to do that for protecting an asset from creditors. And that was the reason why we did this. Because when I first undertook this assignment, I looked at their existing home to see how they own title to that.
Now, their existing home, let me cut you off real quick, was on the White Castle?
Yes. So the existing home was in the name of Martha Ludwiczak only. But I could tell from the deed that because they used a trustee deed to transfer it from Jim and Martha to the trustee, who was Joseph McKinley, and then the trustee transferred it to Martha only. That's how he had to do it back in 1981. And so I went to the previous deed, and the previous deed for Brancato was to Martha and Jim as tenants by the entirety. So I asked them why they had switched it up, and learned that their concern was because Jim's business is fraught with risk, is a blasting and mining consultant, and then overseeing the development of blasting. So he might be at a coal mine supervising the drilling of the holes and the loading of the holes. They wanted to be sure or have some protection that if something had gone awry and he had been sued in the business, that they couldn't get at the home. And so they took it out of tenants by the entirety and put it in Martha's name only. And so I told them we could do the same thing here if that's what they wanted to do. But I also told them that tenants by the entirety would protect the home just as well as having it in Martha's name only.
Okay.
And so they decided to put it in their joint names as tenants by the entirety.
Meaning, to my understanding is if there was going to be a claim against, there would have to be a claim against both of them rather than, yes, because it's not divisible. The tenants by the entirety means it's not divisible. What the interest in the home is by the entirety.
That's correct, and a creditor of one could not get at the interest of their tenants by the entirety.
Okay. Now, and then we kind of glanced over, or glossed over this, but it was joint for their natural lives with remainder in fee simple, which simply means they jointly owned it, and then upon their passing, it would go to the survivor.
Yes, and it's my practice to always add the phrase as tenants by the entirety. By operation of law, the first phrase would have made it tenants by the entirety, but for purposes of clarity, I always put tenants by the entirety.
Understood. Now, let's see. You also, let me just add this in. We have not discussed the question we're going to be asking. We've done nothing to prep for this deposition prior to today, have we?
We have not.
Okay. You also acted as Martha's, as the executor of Martha's estate, correct?
Yes.
And did you draft Martha's will?
I did.
Do you have a copy of Martha's will?
I do. Because you asked me to bring it.
Yes, I did. We go ahead and have this marked as Exhibit 4. Do you have a copy of this will in front of you? Take as much time as you need to familiarize yourself with this will.
Okay.
I'm going to direct you to the second to last page. Do you recognize, there's two signatures there over the name Martha Ludwiczak. Do you recognize those signatures?
Well, they are Martha Ludwiczak's signature. She signed it in my presence.
Okay. And it looks like it was witnessed by you and Summer Wedding, which I will identify as, that's your assistant, correct?
Yes.
And then it was witnessed by, I do not recognize that name. Wait. Is the notary on that, is that Cleta Brancato?
Yes.
And that's your wife?
Yes.
Okay. If you do not mind, give us an explanation of the drafting and the execution of this, of the will. And by that I mean, did you consult with her? Did you discuss her intent? And then is that what developed into this will?
Okay. Well, over the years, Martha and Jim each told me, we need to come see you and do our wills. And my response would always be, come see me, I'd be glad to do it. When I say over the years, it probably was 10 or 15 years. Probably got mentioned 4 or 5 times over 10 or 15 years. So, Martha was out shopping and ran into my wife, Cleta, and mentioned it again. We need to come in and see Frank about your doing our will. And so, Cleta told her, I'm going to be working next Tuesday. Why don't we just bring you in next Tuesday and we can visit, you can talk to Frank and do what you want. So that's what happened. She came to see me, told me what she wanted to do in her will. During that conversation, she outlined some things that she wanted transferred to the children and to Jim. And she asked about the house on Windsor. And I reminded her that she and Jim owned it as tenants by the entirety, that we could put something in the will about that. She wanted the house to be given to Barrett, or her interest in the house given to Barrett. And I told her that she won't have an interest in the house unless she survives Jim. If she survives Jim, then she would own the house 100%. If Jim survives Martha, then Jim would own the house 100%. And if Jim survives Martha, there would be nothing to give Barrett in terms of Windsor, because she wouldn't have any interest. And I reminded her about what we did back in 2004 and the discussions that we had. In fact, Martha brought me a copy of the of the deed to Bonnie Castle, where only she and Jim had signed it, and it hadn't been signed by Joseph McKinley or filed, and I still have that. So she understood what could possibly happen. I'm comfortable she understood it because I showed her the deed and reminded her about what had been done on the Bonnie Castle house.
Yeah, about what had been done on the Bonnie Castle house, do you mean that the significance of tenants by the entirety and jointly with rights of survivorship held as tenants by the entirety, what that entails, and the fact that essentially it would go to the survivor of them and it would not be controlled by the will?
Yes, and I told her we could do the same thing with the Windsor property if she wanted to do that she and Jim could sign it over to me as a trustee, and that I could then sign it over to either one of them if that's what they wanted to do.
Okay. So you were confident she knew that the devise to Barrett Ludwiczak that is shown on, I guess it is page 4, is 4?
7.
4, 5, 6. I'm sorry, page 7. Under item 5, paragraph 2, she understood that bequest may lapse if she passed first.
Yes, she understood that,
Okay.
and she had a response, and I'm comfortable she understood it.
Okay, what was her response to that?
That if she died first, it'd be something for Barrett and Jimmy to work out.
Oh, and her words were something that didn't work out.
Yes.
Okay. Do you know if she took any other action with respect to the the Windsor Avenue property?
No, I'm not aware of anything else she did.
Okay. Now, with respect to your representation of Jim and Martha Ludwiczak, is there anything else you would want you would want me to know or preserve in the record concerning the Windsor Avenue property? Anything you want to add or that you believe is significant?
Well, I'm aware of the lawsuit because I'm here on that. I mean, I've been ordered by the court to testify and to turn my files over. In this case, to turn those files over. And at no time did Martha in 2004, or at the time of preparing her will, did she ever mention to me that there was any contract or agreement that Barrett would get the Windsor house. And I explained to her, or reminded her about what we had done in 2004 and why, and that if she passed first, there was the lapse of the bequest to Barrett, she didn't have any kind of reaction like, oh my God, there was a contract or an agreement or a promise to transfer this property. She didn't have any of that.
So there was no discussion with Martha, either when you were preparing the Windsor Avenue deed or when you were preparing her will, which you referenced in the agreement with Barrett Ludwiczak.
There was not. The agreement, the oral agreement, I became aware of that sometime later after Martha died, and I became aware of that through protestations from Barrett.
Okay. Are you confident that Martha fully understood the effect of the term tenants by the entirety as it related to her will?
I'm absolutely confident of that. There's no doubt in my mind.
Now, what's your relationship with Barrett Ludwiczak?
Well, he was a member of the Ludwiczak family, and I think he went on one of the vacations.
Okay.
He didn't go on most of them, but he may have gone on one. It was cordial until the estate was probated.
Okay. What has been your contacts for, I guess you use the term protestations. Has Barrett Ludwiczak contacted you or protested your handling of the estate or the Windsor Avenue property?
He has. He disagrees with the effect of the tenants by the entirety. He's posted about it on Facebook numerous times. He's asked me some questions. I responded to him in writing, and I send the copy to all of the heirs at law.
Now, why do you send copies to all of the heirs at law?
Because I think they're entitled to know. They're also will beneficiaries. So any communication I have with any of the heirs at law or the will beneficiaries, I copy everybody.
If you don't mind, you say will beneficiaries. Do you have the copy of Martha Ludwiczak's deed in front of you? Or will in front of you?
Yeah.
If you can go to, I believe it is page 5. The beneficiaries under item 5, it says distribution of the estate. I'm just going to read the names that are listed in there. Can you identify them, please?
Yes.
James Ludwiczak.
Surviving spouse and widow.
Of Martha.
Widower.
Of Martha.
Yes.
Barrett Ludwiczak.
Son of Martha Ludwiczak.
Leanne McIntyre.
Daughter of Martha Ludwiczak.
Bethany Kelly.
Daughter of Martha Ludwiczak.
Lori Scholl.
Daughter of Martha Ludwiczak.
Okay. And then, let me just review this further. Barrett. All right. So, it looks like the beneficiaries as listed under this distribution of the estate under item 5, it looks to be Jim Ludwiczak, Barrett Ludwiczak, Leanne McIntyre, Bethany Kelly, and Lori Scholl. Are those that's Martha's surviving spouse and children, correct?
Yes.
In terms of responses to Barrett Ludwiczak, you can send copies of those responses to all of the beneficiaries under the will?
Yes.
As the executor, I'm guessing you're taking the position that as the executor of the estate, all beneficiaries under the estate are entitled to full and complete knowledge of the communications concerning the estate?
Yes, and the progress of the estate.
Okay. With respect to Barrett Ludwiczak, have you represented Barrett in the past?
Yes.
Okay. In what respect did you represent Barrett?
I filed a Chapter 7 bankruptcy case with Barrett on 2011.
Okay. So he came to see you about a bankruptcy. When did he first come see you about bankruptcy?
2009.
2009.
Yes,
Okay, but you eventually filed a case when?
in 2011.
Okay. Was that correct me, 13 is a commercial reorganization?
Chapter 13 is a consumer reorganization, or where you pay your debts. You make a plan payment for a period of time, and you commit to the plan whatever funds you don't need for reasonable living expenses.
Okay, and then 11 is a commercial reorg?
An 11 is a chapter 13 for business.
Okay, and then a 7 is a liquidation.
Yes,
What kind of bankruptcy did Barrett take?
chapter 7.
Okay. In the simplest way possible, describe what would happen with generally what would happen with a Chapter 7 bankruptcy. In terms of, do you have meetings, the information you gather, what do you want to do with the court?
Well, today is a little different than it was in 2011, but in 2011, we would have people come in, or we'd send them my intake form that they would fill out, and then have a consultation with them, for which I do not charge, where I go over their information and determine whether they're going to be filing Chapter 7 or Chapter 13 based on revenue stream and assets, whatever assets are protected by the exemptions allowed by the bankruptcy code. And then we are required to gather background information and documents to submit to the trustee. Back in 2011, we would mail the documents to the trustee, and I believe it was still done in 2011, that we'd actually bring the bank statements to the hearing. Sometime after that, we started to email the bank statements and scan the documents and send them to the trustee. But in 2011, we were still doing everything by paper.
Okay, hard copy.
Yeah.
Now everything's e-filed. Well, I guess in most jurisdictions, state and federal, it's all e-filed now.
Well, we began e-filing bankruptcy long before that. It's just the documentation wasn't electronically transferred. But we started e-filing, I think, in around 1983 or so.
No.
2003, yes.
Over 20 years ago. Now, did you have, I'm assuming you had several meetings with Barrett prior to filing the bankruptcy?
Yes.
Okay. Would it have, part of Barrett's, well, the main thrust of Barrett's lawsuit concerns the ownership of the Windsor Avenue property.
The lawsuit that we're here on, yes.
The lawsuit that we're here on.
I view that as a quiet title action.
Okay. Would Barrett's ownership of real property been an issue in the bankruptcy?
Yes, in 2011, if he had claimed an ownership interest in the Windsor property, I would have had to prepare his bankruptcy petition differently than it was.
I'm going to, let me ask this. To the best of your recollection, did Barrett ever say or claim an ownership interest in the Windsor Avenue property?
No, to the contrary, he told us he was renting the property. His intake form reflects that he's renting the property. We had some follow-up questions about that, and there's some notes in the file about what his answers were.
Okay. I'm going to show you what's been previously marked as Exhibit 1 and 2. If you would just take a look at those.
Well, this is a lot to review. I mean, I think I'm generally familiar with what's in here. If you want to just go ahead and start asking questions.
Well,
if I need to review it at that time, I can do that.
You recognize the back. That's what I'm asking right now.
Yeah, following the filing of bankruptcies in the last decade, which would be, I guess, 2 decades ago now, 2010, sometime after 2010, we started scanning files. So this is a printout of what was was contained in his electronic file. His file was scanned, I would say sometime around 2014 or 2015, when we took all our old paper files and started scanning them electronically and then shredding the originals, except for the signature pages. I scanned all the signature pages from Barrett's file and every other client's file.
Do you have a copy of the I guess, original signatures for Barrett's filings?
Yes. Here. So in Barrett's file, there's a thumb drive now
Okay.
with all the electronic. Here's his wedding signatures and what he signed.
So that is you still maintain in your file the original signature of Barrett Ludwiczak dated February 18th, 2011?
Yes.
Okay. I'm going to hand this back to you. I want it noted for the record that this is a original wet signature. We are not going to make it, or I'm not going to make it a part of the exhibit just because it is Frank's file. But could you actually read on the admonition immediately above Barrett's signature?
Well, at the time, before we filed bankruptcy, just before we electronically filed bankruptcy, we meet with the client, go over the bankruptcy, and stop page by page. He signs several times. 6 or 7 original pages here. Each page has a similar admonition, but the page 3 of the petition has this admonition. I declare under penalty of perjury that the information provided in this petition is true and correct.
Okay.
Where is the part where I actually said that I'm renting?
Listen, Mr. Ludwiczak, you'll have the
Just one more at a time on the witness, please.
yes, you'll have the opportunity to ask those questions once I pass the witness. Now, if you don't mind, can you identify actually in the bankruptcy petition, I guess, Exhibit 2, where Barrett would have identified or listed a interest in real property, which would include the Windsor Avenue property? And as a hint, I'll direct you to page 19, Schedule A.
Well, that's the Schedule A, page 19, is the first reference to real property. There's several references in the bankruptcy court about whether you have a future interest, contingent interest, those types of things. But this is the first reference to real estate, and the response and representation is none.
In terms of, let's go from the simplest to, I guess, more esoteric. This Schedule A would refer to, I guess, it would be like a vested interest, somebody who currently owns real property, correct?
Well, it's more than that. It says, if the debtor holds no interest in real property, write none.
Okay.
So it's broader than just present interest.
Okay, well, you mentioned contingent interest and future. Where in the bankruptcy petition would it provide for contingent or future interest?
Page 22. 19.
Okay, I'm reading this into the record, where it lists equitable or future interest, life estates, and rights or powers exercisable for the benefit of the debtor other than those listed in Schedule A real property. So would that include any identifiable, future interests such as upon Jim Ludwiczak's passing, if there was something that would then be directed to, or that would be devised to Barrett, would that be an example of a future interest?
Well, will's not effective until somebody passes, so that will be changed. If such a will existed, it could be changed, so that would not be a vested interest.
No, I'm sorry. Give us, if you don't mind, can you provide an example of a future interest, just for illustration?
Well, looking at the tenants by entirety deed on Windsor,
Yeah.
if Jim and Martha had died in a common accident, then the beneficiaries would have been the 4 children.
Okay. And something like that could have been listed here.
No, that would not have been listed there.
Okay.
A life estate, for example, would be listed there.
Okay.
A contract and bond for deed might be listed there.
Okay.
Something like that. Or a remainder interest, a vested remainder interest would be listed there.
If someone's grandmother had passed away, leaving everything to a son and then to grandchildren, where the grandparent has already passed, that would be a vested contingent or future interest.
Yes.
But not an expectation such as what a will says while the parent is still alive.
Correct. The will is always modifiable.
Ambulatory.
Yeah.
I've heard. Now, I just want to note, there's nothing listed here in response to equitable or future interest, contingent, anything like that. There's nothing listed under question 19.
Correct.
Was there any interest in real property that was provided to you or described to you by Barrett Ludwiczak in your consultations concerning his bankruptcy?
No. And Schedule G reflects that. If I get to it. Schedule G asks about the contract or lease or name of debtor's interest for non-residential property. We might have listed it there if he'd have told us about it. It describes unexpired leases of real or personal property. We didn't list one because he didn't have a lease. He had a month-to-month agreement.
Okay. So did Barrett describe to you that he had a rental, he was renting Windsor Avenue from his parents?
He described that on his intake form. It said he was paying $600 a month rent. Then when we looked at his bank statement, he shared a bank account with Jim and Martha at the time. His bank statement showed he was paying, I don't recall, but it was either $235 or $245 a month. And so I don't remember if I discovered that or Summer discovered that. But I asked Summer to contact me to explain the difference between what he told me on the intake form, which was $600 or $700, and $235. And his response was he was also paying the taxes and insurance as part of his rent, and that's how he got to the $600.
So it was essentially almost like a triple net lease type thing?
Yes.
Okay. If Barrett had disclosed there was a oral agreement or some sort of an oral agreement akin to a contract and bond for deed, would that have been reflected in the bankruptcy petition?
We would have to have reflected that, and we would have to have protected it the best we could under the homestead exemption. Now, I think the homestead exemption in 2011, 2010, in that time period. It changes in November of the previous year. Would have been around $15,000 is my memory. I could look it up, but that's my memory. At that time, so we could have protected $15,000 of equity in the property. And I would have done that. Well, actually, I'm not sure I would have filed a 7 because Martha and Jim had put a large amount down on the house, like $35,000, about half the selling price. So right there is $35,000 of equity.
Yeah.
And then they would have paid at that point 7 or 8 years of principal, some additional equity.
Mm-hmm.
And then there would have been some appreciation between 2004 and 2011. I don't know what that was. But might have had to tell them to file a 13 if we wanted to protect it. I mean, there might have been something else we had to address. There would have been something else we would have to address. I don't know what that is. Because that's not what was represented to me.
Okay. If you don't mind, you have the Exhibit 2 in front of you. I just want to go over a couple of things. So we've discussed Schedule A on page 19, where it lists the real property as none.
Yes.
If you don't mind, turn to page, I guess, 38 of 53.
Okay.
It lists rent. And I believe that's $600. Is that what you were discussing as the utilities and then the mortgage payment?
Yes.
Okay. And then it lists on here under 11 insurance, but it doesn't list him as paying any insurance.
Yes. It also doesn't list him as paying any taxes or insurance under item 1 because they weren't his taxes or insurance. That was part of his rent.
Okay. Okay. Which I believe you said was almost like a triple net agreement.
Yes.
Now, you've got also Exhibit 1 in front of you. Is that the intake form that you had provided Barrett?
Well, Exhibit 1 is a printout of the correspondence from the file. This is all the correspondence.
Okay.
So the first page of Exhibit 1 was the most recent correspondence. The last document in Exhibit 1 is my intake form, which would have been the first document we had or generated.
If you don't mind, go back and let's look at that intake form. I guess it's toward the back of the, or the bottom of the Exhibit 1.
Yes.
And what I'm seeing on here is, looks like a 16-page form titled Important Information About Bankruptcy Assistance Services.
Yes.
Client Financial Questionnaire for Consumer Debtor.
Yes.
Okay. On page 2 of that, at the start, or at the top, it lists that this is first name, middle initial, and last name. It identifies as Barrett J. Ludwiczak.
Yes.
On page 3, it has current monthly expenses.
Okay.
Can you describe what is in the, I guess, this first box under the titles? It says your monthly rent or home mortgage payment.
Yes.
Okay.
He checked off rent, wrote down 600, And when he asked, does it include taxes and insurance, I checked no. And that's what I put in the petition.
Okay. Now, on page 4, it also, under section 22, it lists real property taxes. It has something written there, and then it's crossed out with a 95 next to it. Do you understand, or can you describe what that is?
It's on page 4.
Page 4 of 16, box 22.
Oh. He wrote down $1,150 a year. We have to input everything by the month. So I simply divided that by 12 and I wrote 95.
Okay.
This is kind of a live document when I get it, and so I'll make notes on it and make corrections on it as we go.
All right. Could you turn to page 16, or I'm sorry, page 6, question 11 at the bottom, under 11A.
What page was that?
16, oh, I'm sorry, page 6 of 16.
Oh.
11A says, do you own a home?
Yes.
What was Barrett's response?
The response is on the next page. I believe it's no. Yes, he said he checked off no.
Okay. Likewise, if you could go to page 11, where there's a section that says Schedule A, real property.
Yes.
Can you describe for the court reporter what is listed on that page?
So this page is designed to gather information that I need for the petition, and it was left blank because he responded that he didn't have information, he didn't own any property. If you look at page 10, we direct the potential clients to stop at that point, and then I complete the rest of it with the client in my office. And so I struck through that because he'd already checked off he didn't own any real estate, and that was my understanding. He didn't own any real estate, and I had that understanding from 2004.
And that's why it's crossed through that way.
Correct.
Now the last thing in there, last page of this, actually, if you don't mind, go to page 1 of 16 of that. Is that, there's a signature on the bottom of that page. Can you identify whose signature that is?
That's Barrett's signature. He signed it. He signed it at the time he completed it.
Okay, and then the last page is a driver's license.
Yes.
And whose driver's license is that?
That's Barrett's driver's license. It's 4 copies, but that's what it is.
Okay.
It matches his birth date.
And the documents we've reviewed today that came from your file, are they in the same condition that they would have been when you and Barrett completed them in 2011?
Yes, we have.
Whatever the date is, they're in the same condition.
Scanned files. We kept them electronically the same way we kept them when they were paper. So there's and I sent Barrett a copy of his file a few months ago when he asked for it. So there's a drive here that we sent him. So when you go to the thumb drive, there's a folder that says 1 scan pleadings, which is where all the pleadings with the bankruptcy court are. one scanned client documents, which are the documents we received from Barrett and other clients concerning their bankruptcy. So it would have his title, it would have his 6-month bank statements. If he'd owned property, we'd have had a copy of the deed and other things in that. And the scanned correspondence is what we've gone through. Now, the scanned correspondence in this case includes both the files and the letters as we save them, and then there's one file that has everything in it. So there's some duplications in that.
But everything that, even the duplicates are reflected as what you had received from Barrett or you had prepared, and they are in their original forms.
They are.
I don't have anything more of this witness. Mr. Ludwiczak. How about that? You got this stuff. I know that. Just because we gotta get on camera. We'll make. Is there anything else you need to talk about?
Yeah, but the other stuff you got copies of, so I didn't make a copy.
Okay.
So you can make a copy, that's for the thing.
That? Yeah, I guess that's it. We'll just wait until Russ gets back with those copies.
All right, I want a copy of that.
Yeah, I got a copy of that.
The part I got you was just pages from deposition.
Thanks, Russ. Frank, before you get started, did you have an extra copy of the Windsor Avenue deed? I have one. I don't know if I passed it. Is that an extra? You need that.
I don't think that.
Okay. I don't know where mine walked off to, so. All right, I'm ready to proceed if you are there.
I just wanted to ask you, Frank, about the conversations you had with my father about the bankruptcy. Claim you paid for it. You and Frank, which I and Frank got him through, he says. What discussions you had with him about that?
I don't, other than he called me, told me he thought you needed to file bankruptcy, and I said I could help him, help you.
Legal statuses of the house. We mentioned we had that conversation. Remember the conversation we had where you were telling me about the IRA, and he was going to trade me the house for the IRA.
He mentioned to me that he might offer to convey the house to you in exchange for the IRA.
When did you tell him about the IRA? it was going to him?
When I learned about it from, when I contacted the people, I gave them your contact information so that they could contact you directly. That was passing outside the will, because Martha apparently changed it after the will was done. So my initial contact with the financial institution that held the IRA was to request that it be transferred to Jim Ludwiczak pursuant to the terms of the will. And that's when I learned that you were the beneficiary, or you had been named the beneficiary of it. And so I contacted Jim after that and said, you're not going to get the IRA because the beneficiary was changed, and that was the end of it.
When did you tell him that the will, that the wording of the deed was going to keep the house from going to me?
I don't recall. I know I talked to him about the tenants by the entirety fairly early on, but I don't recall specifically.
So I guess the final question: do you have any like emails or written documentation in the conversation you had with my mother? You said you did not fail to have discussions with her about the wording of the will.
We don't have any emails. I had, as I recall, 2 meetings with your mother, and then she came back to sign the will. So it'll be 3 sessions.
How did you specifically describe to her what the wording meant? Because I know you and I both know my mother, and I don't think that's something she'd understand.
Well, I would disagree with you. I think she understood it very well. She brought in the trustee deed involving the Bonnycastle property. She understood why that had been changed then. I told her we could change it, we could change the Windsor property if that's what she wanted to do. The same way she changed, or they changed, the Bonnycastle property.
You don't have any of that in writing?
Pardon me?
You don't have any of that in writing or anything?
Well, no.
So she just assumed that my father would be reasonable?
I didn't assume anything.
She said, Jimmy, we'll work that out.